the House Judiciary Committee, not in our normal place, but we have many folks who wanted to sit in on this hearing. So we're happy to be over here in the Pavilion building this Tuesday, February 4th. And we're going over various issues related to victims' rights. And we're going to start with Jennifer Pullman. So thank you for being here.
Thank you. Good afternoon. For the record, my name is Jennifer Pullman. I'm the Executive Director of the Vermont Center for Crime Victim Services. And really grateful to the committee for making the time for this really important discussion, and grateful to the network for arranging this and bringing so many amazing advocates into the room. I do want to alert you to the fact that I will be attempting to do a PowerPoint at the same time as I testify. That is the first time I've ever done this, and I've been doing this for about 20 years. So you all are the guinea pigs. I did provide hard copies as well because I didn't trust myself. And it is available on the committee page as well. So my job is basically to kind of set the table for the amazing work that you're going to hear from folks who are on the ground and providing the services to Vermonters, to victim survivors. And I want to start with, again, my appreciation for the time today, because victims services, victims' rights, we often feel to be overlooked. And I know this committee has heard that phrase many times about the three-legged stool of the justice system. And one day we will think of it as a four-legged chair. And I've been trying to say that, and it hasn't quite taken yet, but I haven't given up. Because as you hear the testimony that will be offered today, I really want it to kind of sit in the back of your head that the victim survivor in this process is the one who's arguably, and I'll state quite clearly, impacted the most. Yet that voice is the one that is heard the least. That voice is rarely heard. And in terms of our justice system, it's only heard directly when the matter's been settled. It's actually been a conviction. That's at the sentencing with the victim impact statement. So that voice, the voice of the person who's, again, been most directly impacted, and you've heard from survivors before about how this is life altering. Whether that voice is ever even heard depends upon a conviction. And that's why advocates, people that you see in this room, are so important. Because the fight to get a seat at the table, a seat on that stool, to find a place, is a challenge every single day. And I'm so grateful to everybody that's in this room that does not stop from advocating and fighting. As far as the center, we are, again, that weird state agency with no state employees. And as you can see from our mission, we are basically responsible for trying to elevate victims' voice and the voices of advocates and as well. We are established in statute, and we do provide, I think mainly for purposes of today, there's a right to compensation that victims have, a right to restitution. We have 2 direct service programs that do that work. And then also we provide 265 different subgrants out to the state of Vermont to support the work of, again, the advocates like you see in this room today. Oh my God, I'm not even doing my little slide. See, this is what I knew. That's my great slide for that. So just in terms of the overview, again, thinking about really with the role that victims have or don't even have in their own, the criminal justice process in terms of their own matter, their own harm. 39 states have amended their constitution to include victims' rights in them. Vermont is not. In Vermont, all of our victims' rights are based entirely in statute, generally in Title 13, which is our criminal code, and Title 33, which is our juvenile code. The work of this committee was instrumental a couple of years ago in really bringing the rights for victims in conformance with many of those in Title 13. The rights that are in our green books are pretty much coalesced around 4 major areas: services, information, notification, and the right to be heard. With respect to services, that's your victim advocates. And there are state-based advocates and community-based advocates. They kind of just make it a little bit easier in terms of how to break it down. And the state-based advocates are responding when obviously in that more traditional fashion, when there's been a report and there's been an investigation. And currently they exist all on the continuum, which is a tremendous change from when I started this work back in 2002 to 2003, because we now have advocates based, some based in law enforcement, special investigation units, prosecution, and corrections based. So that's been, an improvement in that we have somebody who can serve as that liaison in the instance that a case would go that traditional route. We also have community-based advocates, and that's really where we get to do our grant making and hear about the amazing work that's happening. It's the network, Child Advocacy Centers, Disability Rights, Pride Center, Association of Africans Living in Vermont, Legal Aid, Restorative Justice, and they can provide that support if the victim is engaging in the traditional system, but also outside of the criminal justice system, addressing relief from abuse orders, housing, employment, maybe custody matters, legal services and mental health issues, and not issues, but we're making referrals. And I really want to underscore, they provide services and support to victims who do not. And you've heard a whole host of reasons why victims do not.
Right.
Thank you. I'm wondering if, as you're going through these, if you can say which ones are confidential advocates and which ones are not, just so that we can be clear on that.
Sure, like I can see Sarah, and she'll address that, but I certainly would say generally, I think of the network advocates as confidential. I know that, again, I'm looking at Sarah, so she'll speak to that more clearly. With respect to the right to information, and I'm going to turn to more specific rights and share some of the more important, or I should say main examples, but I am going to speak to what that actually means later on. I also do want to say that the rights that we're going to speak about, as I mentioned, are now largely the same in delinquency and youthful offender matters. But there's that right to information, again, if a report's been made, that law enforcement has certain obligations, as do victim advocates who are based within the system. And, essentially those are, right to information about the arraignment, where you can, who your advocate's going to be, who the state's attorney is, notification about court dates, notification about your rights, such as to submit a victim impact statement, rights to information if the person is actually convicted, protections, and making referrals to restitution and compensation. So those are some of the information based rights that we have in our green books. The right to notification, again, is generally, again, one that is provided in terms of the justice system if you report, and provided by people who work within that justice system. Pre-conviction, you see that a number of points that I think we would all agree are pretty critical that a victim survivor would need to know about, especially conditions of release, if somebody's out in the community, what those conditions are, the outcome of the case. Court hearings is a really important so that victims can attend. That tends to be a little bit compromised with the backlog in terms of trying to move those cases so quickly and how we're actually giving notice to victims as well in a timely way. I've heard of examples of, unfortunately, cases being moved really quickly to do that and victims being given less than 24 hours notice to try to find childcare and to appear for very serious resolutions. Then post-conviction, the right to have notification about what happens to that individual, what status they're on, the ability to sign up for the automated victim notification system, which Jared Malone has heard quite a bit about. And then to participate in the parole process, that becomes relevant. And of course, I didn't have that up. So the right to be heard, this one I want to spend a little bit of time on, in part because I think we kind of assume that victims in some ways might be a monolith, that they all want somebody to be punished. And what we've learned is that that's not the case. The National Crime Victims Legal Institute did a study across the country of victims and survivors. And they asked questions to try and understand what the main determinant was for a victim survivor feeling satisfied with the outcome, or being okay with the, not satisfied with being okay with the process, being satisfied with the process, and whether they would report again. And the number one factor wasn't if it was resolved in the manner that they wanted. Number one factor was whether they felt heard, whether they truly felt heard. That was the most important factor in terms of whether they felt the system, whether they felt positively about the system, and whether they would report again. So you see there's a bunch of different ways that victim survivors can receive notification. And it's supposed to be in advance. What that means is not really clear. They can appear at sentencing, provide their victim impact statement, participate in the plea negotiation process. The court is supposed to take those views into consideration. In sexual assault cases, the victim, if the person is incarcerated, the victim can participate in planning. And we've been talking about sealing and expungement a lot, and victims do have the right to submit a statement through the prosecutor with respect to those processes if the individual is pursuing those. I won't spend a lot of time on victims' compensation because we've talked about it, but victims do have a right to compensation. Again, that's established in statute. It's governed by state statute and federal regulations, but essentially this program, which is housed within the Center for Crime Victim Services, is one that I think can provide significant support for victims and survivors. It is available to victims and survivors simply upon a finding of probable cause, which doesn't mean that that the person has to report, but it doesn't matter if probable cause is found. It doesn't matter what happens with that case. A prosecutor, I just had a state's attorney ask me this question. If I decide not to file a case or not to pick the case up, what happens? And that victim survivor is still available for compensation. Generally, certain expenses are eligible, and I'll have a slide for that very briefly, but there's a $10,000 cap essentially that victim has available to them if they qualify. And that exists in perpetuity. We do not, some states will require that the victim file their claim, for example, within a year, and then they close it out within 2 years or 3 years. Our program recognizes that trauma shows up in different ways at different points along the life cycle. And so the victim survivor can file a claim at any point in time, and it does remain open throughout until that is capped out. We don't have a requirement that a victim cooperate with any prosecution. I mentioned that because other states do, and we're able to do a very short turnaround with that as well, in terms of being able to verify and send that out.
Before you go ahead, Ken has a question, and then Barbara.
Can you just, what do you mean if they qualify?
I'm about to speak to that with my eligibility slide.
Okay, thanks.
Can you tell me how long it's been capped to 10,000?
Since the beginning.
Okay, so there's been no inflationary.
No, unfortunately not. We would love to see that improve, as this committee knows, especially if you've been on it for a little while. Our compensation fund is in deficit, and we're looking at a $500,000 deficit this year.
And just remind me what the beginning of the compensation fund year was. Okay. Decade.
Can I get that to you? Can I get that to you later?
Yes, yeah. Okay.
It predates the center, actually.
That's what I wondered.
Yes, it does predate the center. So I'm thinking late 80s. I want to say like 89, 90.
Thank you.
I mean, I agree. I think it should be more, but you didn't hear that. So here are some of the eligibility criteria as you had requested, Representative Gosselin. The private hurt in Vermont, there was physical injury was reported. And we have, it's not just the direct victim and homicides. We can open up a claim for lots of other family members, and our board can determine whether someone who just suffered emotional harm could also be considered as well. So whether other survivors. So we've had the board consider individuals who don't fall within the categories that you see.
Before you go to the next slide, Angela has a question.
Hi, Jen. Can you remind us, what are the sources of revenue into the victims' compensation fund?
Would you like me to speak to that now, or I speak to that towards the end if that's?
No, keep going.
Okay.
The slideshow is fantastic.
Oh, thank you. So as far as, thank you, jinxed it. It's not working.
Doesn't change the fact that the slideshow is fantastic.
Use my.
Technology.
Some eligible crimes, you can see them, I'm not going to walk through them, but generally it's are listed crimes as you, some of you, even the new ones, I handed out that list for those of you, but it's more your personal crimes, the more serious crimes are the ones that are generally eligible. And compensable losses are, there's a lot of different things that we can cover. I do want to speak to, when I speak to the eligible crimes and the losses, I do want to say that the two crimes that are the drivers are, and by the drivers, I mean the one that's the most claims and the most money is provided, reimbursed, is domestic violence and homicides. Homicides are that have been happening are really impacting our fund. So, and then the expenses themselves, generally medical, mental health, and then the expenses related to homicides, funerals, crime scene cleanup. Those are the ones that, again, are the main drivers. Generally, our losses, as you can see, are not covering property. We can cover some property like licenses, passports, glasses, hearing aids, dentures. We do not cover towing. So that's a different topic for a different day. Sexual assault program, I just wanted to speak to briefly, and certainly Sarah Robinson may be touching upon their role in terms of overseeing the same program, the sexual assault nurse examiner, forensic nurse examiner program. But the sexual assault program that we operate under the umbrella of compensation, in this case, the victim doesn't have to report to the police. They have to present for a forensic exam. And you can see the various expenses that are included if in those cases that are covered. We do not bill insurance. This is especially mindful of college and kids and teenagers who might not want their parents to get the explanation of benefits. So we have relationships with the hospital so that is not happening. Restitution is, is our program that we operate. We're the only state in the country that does it like this. We have a fund that's capitalized through a 15% surcharge on court fines and fees and traffic tickets. And in turn, we are able to provide some support to help reimburse the crime-related losses that a victim has. I do want to underscore that restitution is only available if there's actually a conviction and it's based upon a restitution judgment order. So that right to restitution that exists, there's a lot of hurdles that have to be jumped through and a lot of time before that happens. Because before there's even an order, never mind whether or not they are able to see that reimbursement. The good news is that with that capitalized fund that the state set up, we are able to advance individual victims $5,000 from that fund to cover their crime-related losses. If it's a business, we're not able to, and if it's over $5,000, and even if it's less than $5,000, we still have tools that we do look to hold that person accountable. So it's not that we provide that reimbursement to the victim and then the person just walks away. We have a lot of tools in terms of, we could grab fishing and hunting licenses. That's a new one. That's been a real motivator. But liens, grab taxes, lottery winning, stuff. So the person we're still working to hold the person accountable, but our collection rate's about 48%. The old fashioned way we were doing it before 2006, it was about 18%. So again, it's.
Didn't mean to interrupt you. If you go back a slide, you mentioned that Vermont's the only state. Can you share some of the pros and cons of being the only state? Is that a good thing? Is it a bad thing?
I think it's a good thing because this body made a conscious decision when we looked at who was being incarcerated, why they were being incarcerated or re-incarcerated. It was failure to pay restitution. And it really just became this conversation that took on a life of its own in terms of we can do things differently. Because we don't want, it doesn't help the victim if somebody's locked up because they failed to pay their restitution. There was a collection agency that was involved that was adding more to what the person owed and taking more off the top. So it just felt like it was an opportunity to do things differently. And so I don't know why they haven't. I should ask my program manager that, but we feel it works better. Our collection rate is far superior to what it was and to what's happening in other counties, and victims are getting their money right. It takes 30 days when we get that restitution judgment in order to turn it around. And for some victims who've been waiting years, we've heard like, we never thought we'd see anything. And it's frustrating, but it's also gratifying because I know that we can do this more quickly and we can make it happen. And the vast majority, because I was thinking $5,000, that doesn't seem like much. The vast majority of our cases and the orders are under 5,000.
I have heard good things about it. I guess I just didn't realize that Vermont was alone in how we do that. So, right.
Ken and then Tom, have questions.
Can we just back up to the eligibility? Like, how many people there's the record of obviously how many people are eligible, right? But the victims that go through this trauma, how many of them will go to a certain point and then we'll take it to the total end to go and get compensation or what's the word I'm looking for? To like try to move past this to get to closure. Yeah, closure. What is it? 20 up to 20 sessions of mental health and everything. And then does 20 usually do it? I mean, I just asked you a lot, but so
I'll try and unpack them along the way. As far as how many victims, I mean, it gets smaller and smaller and smaller. So if you look at the incidence of crime and then, going down to who reports and then what does the prosecution do with it? And then you talk about conviction. Absolutely, an incredibly important factor. And I'm not just saying this because of who's in the room, but whether somebody has an advocate who is knowledgeable and who's a fighter, because it's not easy. And you've all heard from survivors and the trauma in that moment and the trauma that continues to try to navigate all of that. And again, I think about our own program, providing receipts, all of those different pieces to obtain any modicum of justice is a lot of work. So I'm very grateful to the people who do this work because that needs to be there.
me too. I just want to make sure somehow or another that people are stepping forward and actually attempting, instead of just letting it go under the water or damp, whatever I'm trying to say here. I want to make sure it's being dealt with. Like, I really want to see victims finally have a voice or more of a voice. And the people that do the bad things pay the price.
I could not agree more with wanting victims to have a greater voice in the process and a greater voice in terms of making sure that the needs that they have are met. So absolutely.
Are we doing our due diligence?
Well, I'm going to speak to the fact that, a lot of this, in fact, I'll just go to my next slide if that's okay.
For some reason, I'm way ahead of this today.
Thank you.
Before you do, Tom may have had a question related to the eligibility.
Actually, I'm back to the restitution part. It's 15% traffic ticket fines, fees that build this capitalized budget for. Is there any forecast now? Where it's at compared to years past?
I can go to my last slide. I've only got 3 more to go.
Oh,
Counting this
Okay,
one.
never mind. I'm getting ahead. Maybe you'll answer my question.
Patience, my boy, patience.
You went backwards.
Because I'm kind of building this up, although your questions are suggesting I have something else in mind to say, like, this all sounds really good. We've got these great rights in those green books. And we've got this nice continuum of advocates, right? And we've got these community-based advocates who, you know, are out there and they're able to provide all the support and identify needs. So it all sounds pretty good. But there is this, the challenges, and you've all hinted at what those are. I'm going to start first with this one. There's a ancient phrase, and I don't know if Latin's that ancient, but the states, there is no right without a remedy. That dates back, that phrase is actually the Latin, I'm not going to try and pronounce it, but it goes back to the days when lawyers would use Latin, courts would use Latin. I can remember it's a local, I can't remember many other ones, but the concept being there is no right without a remedy. We mentioned that 39 other states have included a Victims' Bill of Rights in their constitution, not Vermont, all in statute. Not only do we not have it in our constitution, but our statutes make it very clear that victims have no remedy. If you just do a cursory search, you'll see that there are many hurdles. The word reasonable, the practicable shows up quite a bit. We actually have a statute that is very clear, 13 BSA 5319, that a victim is not a party. We have other provisions in statute that say failure to X, let's say notify the victim, shall not delay. So we've gone so far, not only do we not have it in our constitution, but we've been real clear in our statutes that these all look really good, but you're out of luck if you expect there to be any way that we can enforce those rights if they are not realized. There's a concept that I cannot even going to dust off the law books to go over this, but legal standing. And generally, standing to appear in court to bring a matter is you have to identify that you have experienced direct personal harm. There's causation, there's between the action and the harm that you suffered, and there's the potential for redress if the court were to rule in your favor or find in your favor. I've been asked by other experts in the country, why doesn't Vermont attempt to have attorneys who assert standing? And I've never known that to be successful, and just was speaking with somebody, a practitioner the other day, who had tried to assert standing and they were denied. So there's, again, I really want to underscore that these rights look so good, but there are no remedies. And I get calls more often than I would like. I didn't get this, I didn't get that, this happened. And I have to basically say, there's not much I can do. Sometimes I direct them to you all, but that's a problem. And it's a problem for us to tell victims that they have rights when they don't have any meaning to them. And again, that underscores the importance of advocates who are going to be there for the victim and try and do whatever they can to try and meet the needs of victims when there's a system that is in place that is not designed to do that.
Before you go ahead, Ken has a question.
What's not a party mean?
They have no ability to be present in court and make any actual arguments. So they can be, the victim can be present, but they can't have an attorney, for example, who would stand up and make arguments on their behalf.
The victim can't.
The victim cannot, unless the court confers standing and allows that attorney to appear. The network has a number of legal attorneys, and I'm sure Sarah can speak more specifically as to what their role is and what their experience is in terms of if they can even get into a criminal court proceeding.
Okay.
Well, that really doesn't make a lot of sense, does it?
Well, so I guess I might ask you a couple follow-up questions to that as well. So victims could presumably sue an individual in civil court for damages done,
Yes.
right? And they could have standing there. The question is whether, so they could get redress potentially. I know there's lots of issues around that, like how much it costs
Mhm.
in a lawsuit, how delayed those lawsuits are. But that's often an avenue for redress for an individual as opposed to the criminal court, which is seeking redress for the community. I mean, that's the way that's largely set up. So I just want to make that there's issues. There's a lot to unpack in just those two things I just said, but it's like, just to make clear, I mean, standing, I guess the concept of standing in a criminal case is something I'm not familiar with, but other states do allow folks to.
Yes, actually, they do. Again, that was asked of me by several practitioners in the state, including the director of the National Crime Victims Legal Institute. Why aren't you able to assert standing? It's pretty basic. And I was like, we're not. So,
So are you able to point to how some of those other systems work as far as having a victim in a criminal case actually as a party?
I hadn't prepared for that today
Okay.
because I was mindful of my time, which I hopefully I haven't gone too much over. But I'm certainly happy to provide that information. I know that the director of that organization would be happy to provide a statewide, national view as to that as well.
Right, thank you.
All right, so to kind of lighten the mood, I did find this little passed out piggy bank, because that's how I sort of,
So
Yeah.
before you go on, Angela has a question.
Well, or I had like okay, just to, I maybe put an even finer point on this issue of standing. Can you, I think I know, but can you say a little bit more about why that is so important? Because my understanding is that if a victim were granted, if a victim had party status, a lot of what we try to convey or confer through our rights, victims' rights, would almost naturally flow, more naturally, I'll just use that word, to the victim, because things like notification and things like that happen more reliably if you have party status. Is that correct?
I would assume so, as we don't operate in that system, but I know from other,
Well, considering that we have a defendant
Mm.
and a state as prosecuting the case, like they tend to communicate with one another and the things that they're required to communicate.
Mhm.
And because we have this lack of status for victims, the victims are left out of that communication loop.
yes,
Could be left out
Could
of
be.
that.
yes.
I'll put it that way, could be left out of that communication loop, whereas if they were granted party status, if we were doing it right, I presume, they would be required to be a part of that communication loop. And communication is only a part of it, but it seems like a lot of the rights that we're trying to provide for victims, which you have very clearly laid out and then said, and by the way, there's no way for victims to really assert these rights. Some of those would be more readily conveyed if victims had party status.
It would shift the balance for sure. You'd have like half a leg of that chair that would be there, so like 3.5 legs, but it would shift the balance. I mean, I'm thinking of a situation, let's say, this is Maryland addressed a similar situation and the victim ended up prevailing. But I'm thinking of situations where there's a change of plea or there's a change in a sentence that's already taken place after the fact, and the victim should be notified of that, and they're not. And also that resulted in a change in the sentence. That would be something that you can't like go to civil court. You can sue, I suppose, but the redress there would be, hey, I didn't get notified. I should have been heard by the court before the court decreased the sentence. So that would be an example where where we would want to see some way of fixing that. And there was a recent case in Maryland that recognized that, yes, that was wrong, and we need to revisit this, revisit what happened. That's the Said case, SYED. But so it can work. It certainly would not be appropriate for every time that, you know, a notification didn't happen or law enforcement didn't give the victim the state's attorney's information. We're not talking about that. I think there's like these larger issues that when they come up, they're catastrophic for the person that's impacted.
So I'm gonna ask a follow-up question as well on this issue. So presumably the concept of standing and party status is it's a limited role that the victim would have in the case,
Mhm.
because presumably they couldn't hold up or be part of the plea bargaining necessarily. It's a little bit of a different kind of status. And I guess I'm just wondering with the Odyssey system, with that system, why can't this be somehow automatic, that there's a victim that gets notified electronically, because that's what happens now with the parties, is my understanding, is that things are fairly automated. You know, if somebody files something, there's a notice, or am I not understanding the way Odyssey works? You know?
No,
So,
in fact, I think victims advocates sometimes are in the.
right, but so if the victim advocates are there, why isn't the victim there? It's not that, I can't imagine it's that complicated to have a victim have that kind of status where any kind of filings in the court or any setting of schedules, that there are emails that go out, that it would go out to the victim. That would seem to be something. Have you looked into that kind of option?
I know that Attorney Leaders, Direct Leaders Dumont and Annie Noonan are scheduled to testify, and they could speak more to that. But I know that there have been conversations with the folks who, the vendor for the Department of Corrections system, that this should be all across the board. That could be a notification system, that could be present for law enforcement, for prosecution and the like. And I can't obviously speak to what those conversations have been, but I'm sure that if there's a resolution out there that would efficiently get that information out to victims and also potentially alleviate some of the workload that the advocates have, that would be something that I think everybody could rally around.
And just as a precursor, probably to your next slide, if we had enough victim advocates, maybe there wouldn't be notifications falling through. You know, that's happening where you have a victim advocate having 700 plus cases, that sometimes notifications may not be passed on. But that's probably your next slide, so I'll let you.
Yes, the funding slide. As most of you on this committee have heard, primarily we fund victim services through federal funds and special funds. And the center obtains a very minuscule portion of general funds that are straight passed through to some of our programs. So we're a state agency that basically receives no state funding and no support for increasing salaries for our subgrantees, like COLAs and Pay Act and all these things that other employees get, state employees get. Our subgrantees have been level funded for over a decade. I've spoken before about how not having general funds is very challenging. It creates a very unpredictable environment for building a budget. We don't even find out what our federal funds are until early October, late September. And so programs are trying to build a budget as of July 1st, the start of the fiscal year. That creates a challenge. These funds are declining. Special funds that support the compensation special fund, the DVSV fund, and the restitution fund have been in decline since before 2013. In fact, there was a report that was commissioned, but the legislature was involved in, that was issued in 2013 that said, this is not tenable. This can't be done anymore like this, and we need to find a different way. So it's 12 years later, and we're still having the same conversation, despite the efforts of this committee and the body to try and make some changes to the surcharge. Because those special funds are from that surcharge on, again, traffic tickets and criminal fees and fines. And those have all been in decrease, for some in part because of change in practice and reforms. And those are all very good things, but it impacts our funding. And I do want to underscore that the over-reliance that we have placed on federal funds is really playing out recently in a very catastrophic way, where we have gotten so many different pieces of information about what to do with our federal funds and what can be done and can't be done, that we have some of our sub-grantees that are saying, we got to shut our doors. Because we don't know, and they're worried. They're worried. We took this training. Do you think that we'll be in trouble? So these are real questions, and they're impacting service delivery, and they're impacting people whose jobs are already so stressful that, so, I don't even know what the future holds for the center. Because if the federal funds, we don't know. So we're operating in a really tense environment, and it's just not fair to ask of the people that are doing this work. It's just not fair. Our advocates are doing more with less. Cases are becoming more complex. When we talk about complex cases, and we often talk about them in terms of, oh, it's more difficult to prosecute, or the challenges that defendants are presenting with, whether it be substance use, misuse, or mental health. But that presents challenges for victims' services as well. And our victims struggle with the same issues too. So they're trying to work on more complex cases. And again, we're talking about services that have been level funded for over a decade. So the cases are getting more challenging, but we're not investing more money. We don't have more people to do the job, and they're just trying to figure out ways to keep the doors open and to make sure that they're providing those services. And again, the impact of the reforms I completely agree with. But when we talk about adding different pieces to victim advocates, and we talk about how our reforms impact funding, that creates, again, a more dire situation. So the funding piece, just here today, mindful of my time to create this situation, this piece of where we're at. I know you hear from a lot of people about the challenges they have. I'm here to tell you, this piggy bank, she is the reflection of where we're at. There's nothing left. The last week has really shown that we've been walking a real 5 months. So, I really don't want to take any more time. I really want to be mindful of the people that are in this room and give them space to share the important work that they do and the challenges that they have. And again, really thankful to this committee for always creating space for victim survivor voice.
Any other questions for Jen? Okay, so good. Thank you very much. It was very helpful. And if you haven't already sent that testimony to Nate, please do.
Yeah.
Okay, great.
So I just.
Oh, there you go.
There, I think we're good. Or that's, there we go. Perfect. Thank
Thank
you.
you.
Yeah, thank you very much. So. Bless. Thank you for being here. Yeah, I appreciate it.
Thank you for having me. And thank you for holding this important conversation. Sarah Robinson, Vermont Network Against Domestic and Sexual Violence, for the record. The Vermont Network is Vermont's leading voice on issues related to domestic and sexual violence. And as you know, we're a membership organization, and our members are 15 independent nonprofit organizations that provide services to victims of domestic and sexual violence. And today I'm joined by dozens of advocates and survivors who have traveled from across Vermont to meet with legislators and talk about the vital work that they do every day in their communities. And it's an honor to really represent these dedicated professionals. Often when I'm speaking to you, I think about all the people that are in the room here, kind of sitting behind me. And we also honor the voices of survivor activists, some of whom are here with us today, who help us really learn to make Vermont a safer and more supportive state. I'm going to talk to you a little bit specifically about the role of community-based victims advocacy, which you heard some from Jennifer Pullman about. But domestic and sexual violence remain a leading public safety and public health challenge here in Vermont. Just last year, our member organizations answered over 22,000 hotline or chat line calls from Vermonters seeking support related to domestic and sexual violence. And our members work directly with thousands of Vermonters to help them find stable housing, access the legal system, and get connected to other resources. And as you heard from Director Pullman, while victims are those most directly impacted by harm, they often lack the needed resources and a voice within the judicial system. For many survivors, the justice system fails to deliver a sense of justice or to provide meaningful protection, many times due to some of the issues that Jen just highlighted. And while it is absolutely essential that this system works fairly, works quickly, and works well, when survivors need to access it, many survivors who work with our member organizations, likely most of the survivors that work with our member organizations, never choose to report their experience to law enforcement or to access court protections. Survivors are often weighing complex and competing factors when determining how to keep themselves, their families, and their children safe. Community-based victims advocates, like those who work for Vermont Network member organizations, serve a unique role in our communities. These advocates provide individual support and can help survivors understand their options and the risks and benefits that they face. This role is different than the role of state-based victims advocates who work in a variety of state-based settings. You just heard there, we are lucky in Vermont to have state-based advocates who work in state's attorney's offices, the Vermont State Police Major Crimes Unit, the Department of Corrections, and the Attorney General's office. Those state-based advocates help survivors and really serve as a liaison between survivors and the systems as those systems are moving those cases through various points of the judicial system. Community-based advocates at our member organizations also work with survivors as their cases proceed through the justice system. However, they also assist survivors who are accessing the civil and family court systems, where domestic and sexual violence is especially present in protection order proceedings, in parentage cases, and in divorce cases. They also provide support resources and referrals to many survivors who never access the judicial system, but benefit from housing and economic resources, support groups, and more. These advocates also work with victims at many different points in their healing process. That could include working with a child whose parent is in shelter, to working with an adult victim of child sexual abuse, who is working on their healing many decades after being harmed. Community-based advocates are also unique in that they possess a heightened level of confidentiality, which is codified in Vermont statute. That also sets them apart from state-based victims advocates. These advocates are referred to, Representative Rachelson asked the question about confidentiality. They're referred to as confidential advocates. And they have what is called crisis worker privilege, which helps protect their work and their communication with survivors. Crisis worker privilege helps ensure that community-based advocates can be counted on to hold the identities and information of survivors privately, and can only share information with other professionals with a specific and time-limited written release. Despite the essential role that victims advocates at our member organizations play in the justice system, these providers have been completely flat funded for over 15 years.
But before you go ahead with that,
Yes.
Karen has a question.
Yes, about the confidentiality piece. I appreciate you mentioning that difference because I don't know if we've really looked at that in this committee before, understanding the, I forget what you said, state-based victim advocates and community-based. Do you think victims are aware of that confidentiality difference, or how, can you speak to how that's, I just don't know if I would realize. I think a victim advocate is a victim advocate. And so that seems like that's a big piece.
For many survivors who are navigating, especially the judicial system, every part of that system is new. And trying to figure out who the various players are, what their roles are, is a learning throughout the process. think victims advocates do their best to try to describe their various roles. But I do think it can get confusing for victims and survivors.
Do you have I'm curious, I mean, this is something we can ask some of the other providers that are coming. I think an example of the confidentiality that a community-based victims advocate could hold, but state-based couldn't hold.
Yes, so in many states across the country, for example, and Director Leaders Dumont, when he testifies, can speak to this as well. The victims advocates that are housed at state's attorneys or prosecutors' offices in many states are called victim liaisons or even prosecutors' assistants. They're not necessarily called victims advocates. And one of the reasons for that is that typically their interactions with victims, prosecutors have access to those interactions or the information that is shared. Whereas if you're working with a community-based victims advocate, you're not going to be releasing the contents of a conversation or work that's happening unless the victim expressly asks you to.
Okay, and so in our system, both are use the same term, victim
That's correct.
advocate. Okay, so I feel like that could add to confusion as well. Okay, thank you, that's helpful.
So I want to return a little bit to speaking about the funding revenues for community-based victims advocates. In 2008, the legislature established the Domestic and Sexual Violence Special Fund. It is comprised of two revenue sources that are fines and fees, and was really intended to provide ongoing and sustainable funding for community-based victims advocacy. So there's two sources of the fines and fees: a surcharge on civil and criminal court judgments, as well as a surcharge on marriage licenses in Vermont. All of those revenues support just under $1 million in expenses annually, and those funds are distributed among Vermont's 15 service providers through a funding formula. And so organizations within the Vermont network, member organizations, receive anywhere from, on the low end, about $11,000 a year up to about $50,000 a year. And the special fund has experienced a deficit each year since FY15, with the exception of just one fiscal year. So the Vermont legislature has had to make one-time appropriations to make the fund whole to prevent cuts. And in FY26, we are anticipating already $175,000 deficit in the fund. And with the increased need for services, the complexity of cases, lengths of stay in shelter, I often talk about, even when I started at the network, it was not uncommon for folks to come into a domestic violence shelter and need to stay for 30, maybe 60 days. We have folks that are staying in shelter for up to a year, even longer into transitional housing, because it's so difficult for them to find affordable, stable housing. So the shelter system really gets backed up into less ideal emergency housing situations. Even if the fund is made whole this year, it cannot meet the needs of Vermonters that are served by our programs. Wanted to speak specifically about federal funds. So combined, our 15 member organizations rely on over $8 million in federal funding. And for some of our member organizations, federal funds comprise close to 3/4 of their total budgets. And uncertainty on the federal level is really threatening the promise that we make to Vermonters, that there will be access to services 24 hours a day in any community in Vermont. We very much look forward to returning to you all in the coming weeks to discuss budget needs in greater depth, and very much appreciate the time that you've taken on these issues. There's one question that came up earlier that I wanted to just speak to around victim notification and the right to notification. The idea of automatic notification. So we certainly believe that information about the status of a case is incredibly important to victims, but I would also say that context is important, and that getting notification without context of what those changes are is very difficult. So as much as automation is certainly helpful, if you get a notification that there's been a change of plea and there's a hearing tomorrow, without the help of a victim advocate, you may not be able to understand A, what that means, or B, what it means for you or how you can have your voice heard in that process. So it really is this important relationship between information, but also advocacy and support for victims. And one really can't exist without the other. So I'm happy to take any questions that you might have.
Just on that last issue, I mean, could it be some combination where there is automatic notification, but a clear avenue to go to a victim advocate for further explanation?
Yes, absolutely. And I would say that the notification will only be as useful as victims being able to access victim advocacy to support them.
Questions for Sarah? Tom, going Tom first, and then I'll have a
Do
question.
you know where that fund shortage is coming from?
It's coming from both revenue sources. I would say primarily, the Joint Fiscal Office has issued several reports over the past many years, but most recently in 2022, I believe, 2021. And there's a distinct decline in the surcharge on court fines and fees that help fund the revenue source. And I think that there's several reasons enumerated in that report for that. One is the reduction in traffic enforcement and the change in policing. But the other is that understandably, courts also will allow defendants to not pay if they experience financial hardship. And frankly, we support that. We absolutely know that people, low-income people, can be justice involved themselves. And we don't believe that it should be on the backs of people that are involved in the justice system to fund victim services.
I didn't want to hear the first part.
So just looking ahead as far as the uncertainty with respect to federal grant monies. I know that that was withdrawn, but I'm concerned that money could be tied to not providing services to LGBTQ populations. And have you thought ahead of what to do in that scenario if that's what grants are tied to, that agreement?
We continue to be deeply concerned. So during the freeze and all the uncertainty last week, all the portals that, nonprofits, and especially in our relationship with the federal government, we operate on agreement and some faith. Because all of the payments that are provided to nonprofits are on a reimbursement basis. So we don't get upfront funding for our services. We actually do the work, spend the money, and then get reimbursed for that by the federal government. So we were in the situation, especially last week, of having our member organizations who had expended significant amounts of money. I spoke to one of our member organizations that runs a transitional housing and rapid rehousing program. They had spent $60,000 on rents that had been paid to Vermont property owners to house survivors that they were waiting on reimbursement for and could not access reimbursement for. So that kind of uncertainty is very significant and destabilizing to services that are able to be provided in the community. And while the funding freeze memo was rescinded, we have since received memoranda about the other executive orders, including the so-called Defending Women executive order that you just referenced. And we're still unclear about the impact of that executive order on the work of our member organizations, but are concerned about it.
Couple more questions. I guess one follow-up is, as you are understanding that better, if you could keep us in the loop as well. I think there should be some contingency planning if that does impact that. And we are going to be soon in budget discussions. So the others, has the portal been available? Have you been able to access since that? Because I've heard some organizations haven't had trouble.
The portals have since reopened, and most of our member organizations have been able to draw down and receive deposits. Our understanding is that there are some grant programs that do fund this work and the work of some of our member organizations that remain in a state of being frozen at the federal level to state agencies who then pass those funds down through communities. So we continue to be in contact with our national partners and with our state funders as well, who are seeking to access that. And I want to say we've experienced really proactive and helpful outreach from both the Attorney General's office and the Treasurer's office on these issues as well.
Just one last question before I go to Barbara and Angela. So the contingency planning, or hopefully there's going to be some, would it include how, if that money went away, we first have to try to presumably find how to backfill that, given these pretty critical services. But also the question of just how the process of distributing funds. I mean, is that part of discussions with the treasurer? And
That has not yet been part of those discussions. We've kind of been in an information gathering, what's the status and, you know, in conversation with our member organizations pretty much daily about their ability to access funds and be able to actually draw down. What I will say is we feel really lucky because our member organizations have a statewide funding formula. So we have a formula that they do a lot of work around that takes into account population, geography, the services that are offered, and is a very quick way to equitably pass state funds through to every community in Vermont. And we feel very lucky that that formula exists and that our members work so hard to keep it updated. And that's how many of the funds flow from the Vermont Center for Crime Victim Services out to our member organizations is directly through that funding formula.
so if we sometime have to do more funding of some of these services, that infrastructure sounds like it's probably already set up.
There's a very well-established path for that.
Barbara, then Angela.
So again, you're talking about the community advocates, but I just want to make sure that our committee is clear. The government advocates are also funded from federal money, is that correct?
That would be a great question to ask Director Leaders Dumont or others. But I do know that there are federal funds that do support various victims advocacy, though my understanding is many of the state-based victims advocates in Vermont are now funded by general fund dollars.
Okay.
And so that is a distinct difference, I think, between the risk that community-based advocacy organizations face.
Right. And I know that the ones that are located in community-based organizations who have had years of level funding, I don't know what the level funding is for that state general fund bucket that you refer to that has the formula. Like, has that kept up at all with inflation?
No. To answer that question.
So I think Jennifer Pullman could answer one of the other questions here. Go ahead, Jennifer.
And Jennifer Pullman, for the record, as far as general fund dollars, the law enforcement advocates for the state police are funded with general fund dollars thanks to this committee's initiative. The Attorney General Victim Advocate is now funded entirely with general fund dollars, and thanks to this committee's initiative. And the Department of Corrections receives general fund dollars for their advocates, and as of a few years ago, the state's attorneys advocates funded with general fund dollars, no longer with.
Fully.
As far as I know, I'm obviously Director Leader Dumont will correct me, but I
Okay.
know that they used to be funded entirely with federal funds, which was very dangerous.
So it might make sense for committees to look at what are the most critical victim service roles, because we do have a pot of general fund money that currently is funding certain functions that may be redeployed. I mean, the state does commit to some victim services, and that might be important to open up as a contingency measure at some point.
Right, when we start digging into the budget.
Yeah.
Hopefully there'll be a little more clarity by then. Yeah, Angela.
So Sarah, I don't want to assume what your budget presentation is going to look like, but you may already be doing what I'm going to ask, but I'd be very interested to see a number that represents a fully funded victim advocate, statewide victim advocate network that is not reliant on federal funding. Obviously, I'm not saying that this would happen, but I really want to know that number. And as we endeavor to shift more to the four-legged chair, which I love, I'm gonna Love that visual. It's gonna stick, Jen. I'm thinking about how we fund the other legs of that chair and how reliant those legs may be or not be on federal funds. And I would just like to see more equivalency there. And so I'd like to know, you mentioned the $8 million that the 15 member organizations, about $8 million a year rely on federal, $8 million of federal funds. So that plus, you know, the deficit, current deficit, and I would say the accumulated deficit, you know, due to failure to keep up with inflation and real cost of services and things like that. Because the numbers that you're talking about, you know, $50,000 grant here, an $18,000 grant there, that can't even fund one position. So it's so, it's really frustrating. And when we talk about money and budget as value statements, I just want to be really clear about what we would need to better support our values by more fully funding statewide network of victim advocates.
Yeah, we've been working on that, and especially with last week's federal funding that had us looking at that issue in a different way. So very much look forward to coming back to the committee and speaking with you about that.
Thank you.
Any other questions? So are we having Charlie as well?
No, nope, just
All right, great. So we will go to Avaloy?
Avaloy.
Avaloy. Sorry, Avaloy Lanning, if you please
I
join
can
us.
tell
Thank
when
you.
it's my turn. It causes that hesitation.
Thank you for being here, Ava.
Thank you so much for having me. Hello,
Hello.
I'm Ava Loy Lanning. I'm the Executive Director of News Story Center, for the record. And I am so pleased to be here in this room with these amazing advocates and with you all who are doing so much work on our behalf in Vermont. And I guess I'm representing the community-based service leg of the stool. And I proudly am here in that capacity and to talk about our work, which everybody get comfortable because I can talk about our work from now till it's supper time. So get ready. I won't. Sarah's told me I only have a small amount of time. As I said, I'm the Executive Director of News Story Center. I have proudly been in that role since 2015. And News Story Center is the domestic violence and sexual violence service provider for Rutland County. And I am so fortunate to do the work that I do every day with the talented, compassionate, passionate, funny advocates that I get to work with every day, and am deeply honored and privileged to get to walk along beside the victims and survivors that we work with, and that they trust us to walk along beside them. So to tell you a little bit about us, we work to end the cycle of violence through support, education, prevention, and collaboration throughout Rutland County. The name News Story Center reinforces the message that victims of domestic violence and sexual assault can become survivors, and that each survivor can truly write their own news story. And we are, as I said, we're honored to be a piece of that and a small part of it. We have 8 staff members, and they provide, our team provides 24-hour a day, 7-day a week services to survivors and their families. We provide emergency shelter, a 24-hour crisis hotline, legal advocacy, prevention, education, supportive case management, weekly support groups, sexual assault response, and so much more. We don't do our work in a vacuum. We are proud members of our Rutland County community. We are deeply glad to serve alongside the other service providers in the community and our law enforcement and our hospital and our business community. We are grateful to be a part of that, what is a really wonderful community. News Story has been a pillar of support in Rutland County for 45 years. And we provide critical services to survivors of domestic and sexual violence. In FY24 alone, we served 789 victims, survivors, and their children. In FY22, so far, we have already responded to 10 sexual assaults that have been reported to the Rutland Regional Medical Center. And we've worked alongside those forensic nurse examiners that Jen talked about earlier. With help and dedication of News Story advocates and the sheer tenacity of the survivors we serve, we currently have moved 8 survivors and their 9 children into a permanent, safe, stable housing. A housing with no abuser, that they can feel comfortable coming home to every day, that their children can be proud to grow up in, that belongs to the survivor and belongs to that survivor's family. It's a wonderful thing to get to be a part of that. That is funded through our rapid rehousing program. And we are the program that had $60,000 worth of reimbursement that we were thinking, if we don't get this, while we can sustain for a little while, if we don't get this, we're going to have a conversation with landlords we've built wonderful relationships with about not being able to pay the March rent for this survivor. We're going to have the conversation with the survivor. The last thing we want to do is cause anyone any trauma. The ripple effects of this in our communities is so tremendous. And last week was tough. It was a scary time for us, and it continues to be uncertain and scary. Our advocates show up for survivors 24/7 because we believe in the work. We believe in our community, and most importantly, we believe in the people we serve. Yet every year we are asked to do more with less, because believe me when I say level is less. Level is less. We continue because the need is urgent. And if not us, then who? If we see a reduction in funding, what program should we cut? Emergency shelter, sexual assault advocacy, collaboration, prevention efforts, our crisis hotline. Should we stop going to court with survivors as they walk through that process of trying to get their RFA? Where do we cut? Because make no mistake, if we lose something, something will be cut. Any loss of funding will result in a reduction of services. So it's time for us to do more with more. We need more. We need more. Our team needs more. I need to be able to support our team at least a fraction of their value, to a fraction of their value. And I want to be able to do that. I want to be able, when a survivor comes to us and says, I need, or I would like, or this is that thing that's going to help me transition into a life free from abuse. I want to be able to say, we can do that. I want to be able to put that amazing playground on the outside of our shelter buildings so that the kids have a really lovely place to play in the summer. I want to be able to do the things that we can't do, that we dream of doing, but the funding isn't there for us to do. And believe me, I work with a creative group of women who are always thinking of ways to improve our services, to bring more to the people we serve, to meet the survivors where they are and do the work that they need us to do. And we know that there is more that we could do if we had the opportunity and we had the funding. I'll leave this by saying that no Vermonter is safe until we're all safe. News Story is committed to helping make that possible. We are committed to working on this issue every day. We appreciate your commitment to working for Vermonters every day. And we want to be your partner in the same way that we're a partner in our community and a partner for the people we serve. And so any questions that you have for us at any time, you are free to ask them. And I'm happy to take your questions now. And I want to thank you for your time.
Thank you very much.
Thank you. I love the more with more because our sector has become, the nonprofit sector is the, like, we beg for scraps and we say thank you and it's not right. So your comments are so remarkable and inspiring. And I'm curious, having run a shelter myself, how you can do that and everything else with 8 staff. Like, I'm trying to figure out the staffing.
I have no idea. No,
It's like the math that, like, right.
right. They're incredible. So we've recently renovated an old building that we had, and it's incredibly beautiful. And we now have we have 15 shelter spaces that can be configured in different ways. So they would accommodate a large family or a single survivor. And our staff, they're there, they're supportive. We work really hard to build trust. We're available 24/7. That 24-hour a day, 7-day a week crisis hotline is staffed by our team. We have some volunteers that will take a night here or a night there. But it is our team that does that work. And so they are remarkable. I wish they were all here. So that you
For
could.
them to work, I mean, it's amazing work and really important work and honorable work and whatever, I'm just grateful that you continue to do what you're doing.
Thank you. Thank you.
Very much, Sharon.
Don't have a question. but
Okay.
just echoing that appreciation for the work that you do and others in your field do, and for coming here today to share. And that I hope we can do the work to, make sure that the funding's there and the support is there.
Thank you. Thank you so much. Thank you again for having me.
Yes, thank you very much. So we'll have Leanne, did I say that? Did I?
Yeah.
Leanna, sorry. Leanna, I should have known that since you're right from my backyard there.
Over 2.
Yeah, 0 for 2, I apologize. Leanna, thank you for joining us today.
Good afternoon. I appreciate your time and being able to be here with all of you and the advocates today. And I may not be as eloquent. This is first time doing this, so I'll try not to stumble. But yeah, my name is Liana Duda, for the record. I've served as the legal program coordinator at Steps End Domestic Violence since 2020, and I've been with Steps for the last 13 years. Steps works to assist in the transition of safe, independent life for those who have been affected physically, sexually, emotionally, or economically by domestic abuse. We serve Vermont's largest county, Chittenden County. Steps provides emergency transitional housing, 24-hour crisis hotline, legal advocacy and prevention education, support groups, and more. I wanted to speak with you today about the important role that community-based advocates have in our legal system. While victims are deeply impacted by crime and violence, they often have the most limited resources and legal rights. Community-based domestic and sexual violence advocates are an essential part of supporting victims of crime. Unlike state-based victims advocates, as we've spoken to today, community-based advocates like myself and many others here today are confidential. We can assist survivors in understanding their options and navigating in the legal system if they choose to access it. At Steps, we offer legal support and advocacy to survivors of domestic violence in our community. And our legal support includes direct service access for over 660 survivors in 2024, over 90 legal clinics that are offered with volunteer family law attorneys, and over 200 hours of support every Relief from Abuse Order court. It's incredibly important that when a survivor wants to report abuse and the legal system, that the legal system, including law enforcement and courts, work quickly and well. Advocates play an essential role in working with survivors through the system. We know that when survivors can access safety and justice they deserve through the legal system, it leads to better outcomes for survivors and families. Just one example is a mother of 3 children who reached out to our hotline. She experienced years of abuse and was seeking support for her children who had witnessed violence in their home. She was also struggling with complexities of visitation exchanges and ongoing emotional abuse from the father, her children. Without legal representation, she felt overwhelmed by the divorce process and feared the father would manipulate the court system into gaining full custody. And like so many survivors, she had never navigated the legal system before and was terrified of facing it alone. This is where community-based advocates step in. Our hotline advocates provided immediate emotional support, connected her to peer support group, and quickly referred her to our legal program. Then our legal advocates are able to step in, guided her through the divorce and custody process, explained legal terms, prepared her for hearings, ensured her that she understood her rights. And through our free legal clinic, she's able to meet with volunteer attorneys and gain the critical information she needed to be able to move forward. And when she needed more extensive legal assistance, our advocates helped her connect with legal aid and secure a pro bono attorney. And beyond legal guidance, our advocates stood by her every step of the way. They helped her prepare questions for her attorney, took notes during legal meetings, and attended her court hearings with her. Simply knowing she was not alone made an immense difference in empowering her to be able to speak up for herself and her children. More than a year later, her divorce is still ongoing, but she continues to turn to our legal advocates for guidance and reassurance. And we remind her as best we can that her voice matters and she has the right to safety and justice. This story is just one of many. Every day we work with community-based advocates, provide survivors with critical support that they need in helping navigate complex systems, understanding their legal rights, and regaining control of their lives. So as your committee works on issues related to the legal system in this session, we hope that you continue to consider the needed investments in victim services, and particularly in supporting community-based victims advocates. Thank you for your opportunity to speak today and your attention to services for survivors in Vermont. And we appreciate all that you do. I'd be happy to answer any questions.
Thank you. Questions? Yeah, go ahead, Angela.
Yeah. Thank you for being here. I'm just realizing as you were talking that we may not have really spelled out necessarily what makes the confidentiality so important. And I mean, it may seem obvious, but I think it's worth talking about if you can share from your perspective why that is so important, why that is such an important element, given that we have this other state-based advocate, victim advocate who is bound by, laws that require that advocate to share information, to not be confidential, to share information with the prosecutor. So can you talk a little bit about that?
Yeah, sure. I think speaking from what we hear from survivors, many times they are very fearful of accessing supports through law enforcement or going through court and the criminal system. So many times they're fearful of speaking to anyone about what's going on and have concerns that if they share that, balls start rolling and it's outside of their control, like we already spoke to today about how a lot of times then it's out of their hands of what happens in different systems then. So our place can really be that space of safety to be able to ensure that they get the support that they need, the information that they need, and to be able to make the choices that are right for them. So I think that's why being confidential and being able to relay that to people, I think Sarah, one of us spoke to that before of, I think we try our best as advocates to make sure that we share that we are confidential. Victims advocates through the state's attorneys are not. And so we try our best to make sure that that's clear for folks to know this you know, who they would like to speak with about different things as best we can.
Just follow, have you found that any of the survivors are confused by who's the victim advocate, who they can talk freely to, who has confidentiality?
I think it definitely comes up. I think we try our best to continue to share information with survivors because obviously as they're going through a legal process, it's a lot of information coming at them from a lot of people. So I think our roles are always to continue to provide and to repeat that information because many times somebody's not in a space to be able to hear everything in that moment. So we try our best to continue to clarify what our roles are so that they understand.
Thank you. So I'm wondering, having worked in the field, but not in the field of domestic violence, there have been situations where people who were sharing with a victim advocate, a non-confidential one, that information then put them in a safety issue related to their alleged perpetrator because that information was being used. And I don't know if that was in a unique situation or if that's something that you've seen.
I don't know if I could speak to it directly, but I could completely understand why that could happen. Many times I think our victims advocate through the state's attorneys, many times I'll join them for meetings together with a survivor during those meetings. And, you know, they might start sharing something and we might be very mindful of like, let's step out and we can speak separately because of just knowing that information that could be shared. And I think we try our best. That's why I think we try our best to be mindful of knowing that anything that can be shared.
Of course, you can't always be there with it anytime somebody is with a, right?
Right.
Any other questions? So I just have one other one. Have you been able to serve everybody who's come to steps or are there not enough resources to serve everybody? Are there, how many people are not getting the services?
Yeah, that's a good question. I don't know that I have exact numbers, but knowing through our legal program, it's just myself and one other full-time legal advocate. We are continuously busy, and whether through our legal clinic, which is wonderful, we are very lucky to have 6 volunteer attorneys that have supported us for many years through that clinic. They provide so many hours and so much support, but we are usually booked out a few weeks. So even with that, being able to provide a free resource is very limited, and it's very needed to have access to legal advice. Even if they can't represent, that's a very important part of being able to know what's going to happen in any of their legal matters. So I think we definitely are always in need of extra advocates and resources in our legal program specifically. And we don't have the ability to a lot of times be able to go to court to help somebody file an RFA because we just don't. We don't have the ability to always jump off a hotline to be able to go meet somebody at court in that moment. So we try our best, but there's definitely always a need for more availability to be able to be with people in the community, to be with them during those moments, I think, and especially.
Appreciate that. Any other questions? Tom, go ahead.
Aside from your group, are there other people and other than the state's attorneys, are there other people advocating like you do in the city of Burlington, or is there city of Burlington provide anybody that participates in county court?
Well, not specifically in the way we do, because we're very specific to working with intimate partner violence. So we are the folks that are there to help support folks through divorce, through custody matters, child support, relief from abuse orders primarily. But we do actually have a great support through like one of our police departments that does have a victims advocate that also additionally helps to help folks fill out relief from abuse orders, for instance. So maybe that's the 3 of us.
So Do all three of you communicate on a regular basis?
Yes, yeah, that
Daily.
victim's advocate is we all communicate together if she knows that that person needs support from us, connecting them with us and vice versa. We're always
So it could be
connecting
like
both.
a handoff situation.
Mhm. Yeah. Yeah, but it's very limited to be able to have folks be, with somebody in court, as I was explaining, because of how limited we are to be able to be available.
Yeah, go ahead.
Can I add to that? Maybe just a question to Tom's, what you just said about the handoff situation. Is that in any way best practice?
Yeah, so the victim's advocate through it's through Burlington Police, that one, but they usually, what they will do is communicate with the person and connect them, like say, this is Steph's number, this is the legal advocate there, here's their information to be able to say, here's an easy handoff to the legal advocate for additional support and vice versa. Like then we are able to easily share with that person, here's this person through the police department that you can connect with. Here's her cell phone. She can help with these things. It's a much easier system than here, call up random number and, try to get in touch with this person. So I think we try our best to make sure it's as
So
easily
like an
accessible
initial
as possible.
contact and a referral
Mhm.
or something.
And if need be, then we do, I think what somebody spoke with before, like a release of information, if it was something more involved where somebody wanted us to be supportive with another community member like that, we do that all the time too.
I think we're good. Thank you very much for,
Thank you very much for
Anytime.
your time.
thank you very much. So I think we have our last couple witnesses, so I don't think we'll take a break. We'll just go through those witnesses and then we'll probably go back to the State House. So Tim, over to you and Annie if you need to phone a friend.
Thanks. Yeah, and I think we'll be pretty quick. I had the flu last week and still coughing a lot, so I just didn't want to make you all nervous. So I'm sorry, I'm literally right across the street. And with me is Annie Noonan, our Director of Operations and Labor Relations, and she will jump right in if I say anything off base, of course. But yeah, a couple of quick responses. Our victim advocates are funded by the general fund. They are organized and unionized under the VSEA. So we're very proud of that, and Annie can talk about the last few years of how that has gone with contracts. If you guys are interested at some point, it's gone well. Our 26 victim advocates across the state, 600 cases per victim advocate, roughly, sort of a snapshot at any given time. That doesn't include the number of victims that may be attached to a case. So they're working with lots and lots of folks. We do have a resource ask that we've mentioned in the past, but asking for more victim advocates. And you've heard about some of the chronology, the victim's rights, the notifications, the victim impact statements, which are really important, not just at sentencing, but prosecutors look at those. I know I looked at them a lot. I was deciding what to do with the case. And obviously a lot of that pressure, right, to resolve cases as well. Victim advocates are very involved. When we have a day with 40 or 50 cases on for a pretrial, it is so busy for the victim advocates, saying, hey, it could go, it could not go, there's offers happening. So there's that pressure to resolve. And that communication has to get out to victims. But with 600 cases per victim advocate, it's hard to have it all up in front of mind all the time. But our victim advocates do an incredible job. And we're so proud of the work they do to get out the information that they do. Also wanted to say, our victim advocates do have those upfront conversations about the limitations that we have. It also, I think, is important to note, the attorneys have the rules of professional conduct, including Rule 16, the rules of criminal procedure, as well as the rules of professional conduct, which are some special ones for prosecutors. And one of the special ones for criminal procedures, Rule 16, which you can think about as basically everything you need to give to the defense so that they can protect themselves, defend themselves, have a proper sentencing, et cetera. And just a couple of things just to note: the names and addresses of all witnesses known to the prosecution, any information that could negate the guilt of the defendant as to the offense charged. These are things we must give to the defense. under the rules of criminal procedure. Last sort of an umbrella one, anything necessary to the preparation of the defense. And so a victim impact statement, for example, right? We can't hold on to that till sentencing. If we have it on the day of charging, right? It's a part of the discovery that we have to give up. Sometimes people put together the victim impact statements post the sentencing. Sometimes they submit multiple statements, but those do need to go to the defense, and we submit them to the judge too, so that the judge is aware of victim's perspective sometimes throughout the case, but certainly at sentencing if it gets to sentencing. Some of the things that,
Before you go on, just, so you mentioned this is in the rules of criminal procedure, but this is a constitutional requirement, isn't it? As far as what you have to turn over, just to make clear that this isn't just simply the rules that can be changed, it's rules that implement constitutional requirements.
Exactly. So the constitutional due process requirements, which are also embedded in two major cases, Brady and Giglio, which you've often heard about, those are essentially summarized in Rule 16, which we were just discussing. And there are a couple areas which are exempt mostly from disclosure, and that's attorney work product. So when we're talking with law enforcement, here's how to charge a case based on the facts. That's legal advice we're giving to law enforcement. Informants, people that are confidential informants, that's protected. And then for the most part, victims' residential addresses and places of employment are things we can typically keep unless they're so relevant to the defense that we have to disclose them. But we make arguments all the time to keep those things protected. And when we file them under seal, sometimes when we are able to do so. So that there was a couple points I wanted to touch on based on what you discussed. And any questions for Annie or me?
Go ahead, Karen.
Yes, hi, thanks for being here. Going to the difference again between the state-based victim advocate and the community-based. I feel like, again, this is something that we haven't really delved into before in committee, so trying to figure this piece out. And then hearing from one of our witnesses that from other states, the state-based community advocate is referred to as a victim liaison. I'm curious if you see benefit in that name change.
I might let Annie respond to that. She's put her right on the spot. I don't know. I need to think about it a lot. But.
Hi, for the record, Annie Noonan. We have had that conversation about whether it would be more appropriate to say a victim assistance, because in essence, their role is primarily to ensure that the victims are well aware of everything that's happening during any proceedings, what's coming up, all the notifications, assistance with comp and restitution forms. So we have had that conversation. I don't think that would be a stretch for us to get there if people felt that was that made things clearer. Siri Rooney, who was 25 years a victim advocate, is now on the other side of the wall behind me, and she's running the SIU grants program for us. And Siri was just in here listening to this with me a little bit ago, and so I think that her comment to me was we definitely tell victims up front what our limitations are in terms of what we might have to do. She said in 25 years of doing the job, she only had that happen once, where she had to basically reveal that a victim told her that in fact she had not been hit by the abuser at the time. So she said, we're really upfront with people. We develop very close relationships because we're involved with them sometimes for very long periods of time. You know how sometimes cases take quite a long time to go through the system. She said people really do work with us, and they have a good relationship with the community victim advocates and the other victim advocates in state government. So I think it's a continuum of services. Part of what we are very clear about with all of our prosecutors is that the statute provides that victims have a right to know what's happening with their case and to not be surprised by something that's occurring. So, John Campbell, when he was here, we sent out a memo to the entire department, not just the prosecutors, everyone, including our administrative support staff, saying, hey, victims have a right under the law to know exactly what's happening. The victim advocate is supposed to be able to communicate make sure you are keeping your victim advocates in the loop at all times so that they can communicate back to their victims. So, we take that responsibility seriously, and I think that our victim advocates absolutely do. And, I would say that when it starts to break down in an office, Tim or I will get, would get a call from a victim advocate who might be concerned, but we correct that quickly and in the favor of the victim, saying this isn't happening, and you need to make sure you're working with your victim advocate to let them know what's happening with the case. So we have 27 victim advocates across our 14 offices, and I think that they are, they're very close to the actual operation of like what's happening in a quick basis. As Tim mentioned, things can happen very quickly. And our victim advocates are right there, and they're able to very quickly work with the victim. I think that's a benefit because they're so close to the sort of the action of the prosecution. So I'll stop talking. Thank you for letting me share those comments.
Go ahead.
Thank you for both of the responses. I just wanted to clarify too. I think it seems like two very important roles. So not trying to, have the roles competing against nothing at all. It just seems like there also, what I'm understanding is there are differences in it. And I feel like for us as a committee, or maybe just for me, I'll speak for myself. I didn't have that awareness that could be for others as well. And so that's what I think it is. Yes, both roles are critical, but is having the same name for it confusing? That's the piece that I'm wondering. So thank you.
Thank you.
Go ahead, Ian.
Hi, just quick question, 27 victims advocates. Is there at least one victims advocate in each state's attorney's office in Vermont?
Yes, there is.
And has there been for the last year?
Yes, we have had, I'd have to look at the sheet. We have a half-time position that has been vacant for a while in Caledonia. But I think that is the only office most of the offices are fully staffed. And without looking at the list, I can't think of any other office that didn't have a victim advocate in it. Our two part-time offices, which are Grand Isle with S.A. DeSabato and Essex County with S.A. Aluzzi, they have half-time victim advocates because, 32 hours a week. I shouldn't say half-time, they're 32 hours a week. So we are, let me say, I'm sorry, I misspoke. They are half-time. They're 20 hours a week each. Our other victim advocates, if there is a big issue going on, like a jury trial or something, they need support, we'll back up. We'll come up and help in those offices. And but I don't think we've had any offices where there was no one.
Excellent. Thank you.
So just a question, we talked a little bit about some limited standing. I also mentioned the concept of some sort of status on the Odyssey system where an individual victim would receive the notification and presumably could still work with the victim advocate for explanation. Have you looked into, or do you have any viewpoints at this time on those kind of initiatives?
On the party status piece, I was listening to some of the testimony earlier. I think it's when you're talking about what court you're in and why. The criminal division is for the state to present evidence against defendants in the pursuit of justice, and that includes justice for the victim and the community. And so we think the victims are really important in all of that. But also, there's a community side as well. And so the one piece I just wanted to mention is that there has been some conversations in other parts of the country about basically a community advocate, because, right, people want to go in and, Mr. Chair, I know you and I have discussed when like a apartment complex is getting terrorized by drug dealing, that sort of thing. Who's the victim, right? When sometimes there's individual victims. So there's a little bit of something that you'd want to be protective over, that you aren't blowing up court proceedings, but you also, I think, want to have space, dedicated space for the victims there. So I think it's I'd want to think more about it in terms of what that looked like. But, from our end of things, we try our darndest to make sure the victims are aware of what's happening with their cases, because they are often the most important witness in the cases that we're dealing with. So they're not just, people who've experienced harm, they're also key important people to acquiring justice for the community. A lot rides on them. And I mean, I've talked with victims before in the EVA trial that I just felt so emotionally involved with how worried and stressed they were with what they were dealing with. And victim advocate not only calmed them down, but calmed me down as the attorney. So the victim advocates also do that kind of work, also unheralded, in my opinion. But I mean, party status, whatever it may be, we want to make sure that victims are fully heard in all of our proceedings. And under the current structure that we have, we try.
So how about this concept of some sort of status on Odyssey, that they at least are in the loop on what is being filed and conferences, status conferences being set, et cetera?
Yeah, I'll do that thing where I say I would want Judge Zone to talk about the logistics and potential cost and resources and all of that. But there's interested party status pieces in there. So sometimes, for example, in a PCR, even though we are often the entity responding on behalf of the state, DOC is sometimes getting notification, or there's other ways to put in notifications. So if there's a cost-effective way to put in notifications in there, I would want to defer to Judge Zone and Lori Canty and Terry Corsones. But more notification that happens, like you were talking about earlier, I know Sarah was as well, like balancing the human touch, which is so important in these cases. We can never fully automate because we're talking with human beings, but also like a little backup automation and that human approach and the human touch. Like we really value that in our department.
Appreciate that. Other questions? I think we're good. Thank you very much, Tim and Annie, for being here. So I think that concludes the hearing as far as the witnesses we have. Definitely want to thank all the advocates for coming. I really appreciate it. But actually, we have a few minutes that if anybody has a question, anybody wants to have a question for any of us here at the table. I know putting everybody on the spot, you don't have to have a question, but I figured you can always talk to us offline anytime you want, obviously, as well. But thank you very much. Yeah, go ahead.
I'm sorry, I don't know all of your names, but you had asked a question.
And just identify yourself.
Oh, I'm sorry.
That's fine.
My name is Doug Hall. I'm a victim of domestic violence. I received support through Vermont Network, Safe Space, Project of the Pride Center, and also Steps to End Domestic Violence back in 2023. Representative yes, you had asked a question on whether or not 20 therapy sessions was enough. It's not.
I kind of knew that.
Yeah, so if you guys could lift that cap in the Victims Compensation Fund, specifically, I know that I ran into an issue where you can get compensated for mileage going to those appointments as a result of what you've encountered. And I did more than 20 appointments. I used Uber, which is not covered at all under ride sharing isn't covered. There's a formula about gas mileage based on where you live versus where you're going. And then if it's Zoom, you don't get anything. So it's, if you guys could tinker with that, that'd be good. And yeah, I just appreciate all of you listening to these organizations and encourage you to adequately fund them. No, absolutely not. Are we doing our due diligence in that front? There's incredible need. Not just in Burlington and Chittenden, but the whole state of Vermont. It's grossly underfunded, and anybody who works in this space can tell you that. If you just talk to your neighbors. Appreciate that.
Thank you. All right, well, again, I appreciate everybody being here, and hopefully this was informative for folks. And have a good rest of your day. We'll adjourn until 3:30. We'll meet back at the State House. Welcome back to the House Judiciary Committee this Tuesday afternoon, February 4th. So I want to just deal with a couple things this afternoon. We're not going to vote on H.41. I'll explain that in a moment. But I want to talk a little bit about that bill, and then a little bit about H.118, the hate crime bill. So You always think that you've got a bill all the way there and then it's straightforward and then something comes up. No. So the intent of this bill is that it, from what I understand, now this is H.41, is that it's not aimed at fetuses and stillborn individuals, or that's an issue that has come up. And the question was, does this apply? And I don't think we've ever talked about that. I don't think that was the intent of the bill originally. But I'm just putting a pause and have asked legislative counsel to look closely at this and look closely at the language and make sure we're doing what we intend to do so that there's not this unintended consequence. So that's where that bill is. So hopefully we'll be voting on that the next couple of days, but we just wanted to make sure that we due diligence and it doesn't apply beyond what the intent was. So happy to answer questions on that.
No, I'm
as far as I know.
Right, I'm just gonna say it makes sense to me. I mean, there's been many bills passed through this building, over, however many years of unintended. And if we can avoid unintended consequences, it's the right thing to do.
Yeah, right. So that would stall it a little bit, but not by much, I don't think. I think it should be relatively straightforward. We're just making sure. So on the issue of the hate crimes bill, there's a couple outstanding issues. One is whether there was agreement, I thought there was on Friday, to strike the term, and if you see the bill, but it's to strike the term particular. That a person who commits causes to be committed or attempts to commit any crime and whose conduct is motivated in whole or in part by another person's or a group of particular persons' actual perceived membership in a protected category. I think the idea is we did not need to have the word particular, and that kind of confused things a little bit and wasn't very good grammar. So, but I'm open to hear input on that particular issue first. Yeah, Ian.
On that particular issue.
Thank you. Thank you.
3:30 on Tuesday. So totally agree. And I think even we heard testimony that, I may be wrong, but I think we heard testimony that having the particular in there may create the same issue that they're trying to, or it may muddy and have that same problem with like particular victim with a particular group. So yeah, I fully support removing it.
So and for those who were unable to be here, and I know Zach was having a good time in New York while we were.
I didn't catch up on all testimony though.
Oh, did you? Did you watch Smola?
I did.
I thought he was really yeah, he was really good. So in any event, because he kind of went and talked about that. The other was whether we were going to add any additional categories. And I have put online the correspondence that I had with law enforcement. So
did we ever get, not to interrupt you, Martin, did we ever get commissioners' take in writing on that?
I did not, but I didn't. My view of that was that would have shown that I wasn't trusting that Burke was actually reached out to, and he's. He's.
And I don't mean to say that I'm not.
Yeah.
I am questioning him. I just.
Right. But that's why I didn't.
Okay.
Because that would have really been questioning that. I can't trust that you, as a member or as a leader in the Association of Chiefs of Police, don't have that communication with Morrison. And so that's why I did. Yeah. I put that on there, so we have that there. My inclination, as I've explained before, is not to expand the categories any further. There was also a request to look into the possibility of expanding the category to immigration status, which I'm declining to look at that as well. So I think just leaving the category where it is right now and adding that additional language, so we're focusing on conduct, is what I would propose for folks, but I'm open to hear where folks are on this. Yeah. Go ahead.
Can I ask a question about the issue that you're declining to explore?
Yes.
Which I will acknowledge is a tiny exploration of the issue. Well, I was just wondering if national origin may help with
It could apply.
wish
That's
to
why I thought it was
include
fine.
migratory status.
It's a little bit different.
It is, I know, it's a little different, but I'm,
But the reason that it came up was that supposedly in the housing committee, they're looking at that. And it's not quite that from what I understand. It has to do with the social security numbers for getting housing. That's different than protected status. So that was my inclination that, let them figure that out. And if they advance that ball, then Senate can take it up if they want. Yes. I'd rather just keep where we are with it is right now. So where are folks? Are folks good with this right now that we could vote where it is out tomorrow? Giving more people? I mean, I'm not telling you how to vote, just that you're good to have the vote tomorrow.
so the only change to the current draft would be the removal of the word particular
Right.
on line 16 of page 1.
If folks have enough time with this, do we need to hear from anybody else?
And have time to discuss it a little bit tomorrow.
Well, we have time right now. If folks have things to weigh in on it at this point, if people want to let us know. Yeah. On this building. Easy to bring. So,
Do we want to elicit additional testimony?
I mean, if we need to, I mean, I guess, yeah, what would be the additional testimony that you think we need?
Again, the only question I have, and I don't want to go too far down the rabbit hole, but the only reason that I brought up law enforcement in the initial conversation was because we have US Armed Forces and National Guard. So I'm just kind of curious, and part of me is wondering if that could even just be, even if we could consolidate that language into those in service of the country.
Right. I think that gets pretty broad. So frankly, we're I'm not sure when or how US Armed Forces or the National Guard got in here as an additional category. But I'd almost be inclined to not include that because it's different than all the other categories. And this is like it's somebody's choice to go into the National Guard or Armed Forces. You don't have that necessary same kind of choice with a lot of the other perceived membership. But I'm fine to leave that, but I don't want to extend it. It's there. I'm not going to upset that one. But it doesn't fit, frankly, with all the rest of the other protected categories. But I'm willing to let that lie. So you're kind of pushing towards one direction. I would push towards the other direction.
Yeah, no, and I understand.
So
I understand that.
So thus, just leave that part untouched is kind of where.
Leave it alone.
Yeah, that's. Yeah, go ahead, Coach.
I think it gives the entities that have the responsibility being the AG's office and the Human Rights Commission a much clearer perspective to deal with. And anytime that we can do that, it makes life, easier. It's not to say that, we would necessarily decide one way or another, but in the deciding on which cases to take, this will help in that guidance.
Yeah, as far as the other changes that we require. Anybody else want to weigh in? And we can have more further discussion tomorrow if people want, but if people have things to say now. Where's Ken?
Hi, everyone. Ben Novogroski from the Office of Legislative Counsel. I just wanted to clarify the changes to make prior to tomorrow. So removing the word particular from the bill.
Correct.
And then was there another one? I may have missed it.
No, that was it.
Okay.
Yeah. So, all right, so I guess that's that for now. While I have everybody here for a couple of minutes, I know everybody would just love to get out yet again early. And just failing and using and maximizing all of our time, but we can work on other things. So we will have this for a vote tomorrow, and we will hopefully have additional discussion language on 41, and maybe vote that out tomorrow as well. And so we're meeting in here for next week. Just real quickly for next week, in case people have particular witnesses they want to hear from. So we'll probably all day Tuesday and Wednesday, we will get testimony on the amendment that we haven't seen yet on H2, which deals with all the kind of raise the age issues, including delaying raise the age and putting some accountability things in there. So we'll start taking testimony next week on, and we'll probably also start taking testimony on budget and budget requests. State's Attorney's Court, Defender General, Human Rights Commission, victim advocates, CGCs, and the like. So we'll probably start doing that next week as well. Hopefully by then we'll have a good sense of what's in the budget from the governor on those issues, and then we'll hear from the different individuals. There may be one other bill that we'll take up, and it depends on how the other bills that we have on board this week, how they go, including the adoption bill and a couple others that are on the agenda. But the one that Karen, what's the bill number for the writ one that Tom Oliver likes? 21. So we will probably take up H21. We'll probably do another next week, unless we have, but it doesn't sound like we're going to have the domestic violence bills ready yet.
Two would be probably, one would not.
So there may be the bills that are from this year's Fatality Review Commission recommendations that we might take up as well. So anything else, folks? I hate to be done at 10 to 4, but adjourn until tomorrow at 9.